Okay, well, we've talked about areas of practice. We've talked about technology. We've talked about the pitfalls of the disciplinary system and discovery. Now we're going to move to charging and getting our attorney's fees. And for that, we are pleased to have Mary Daniel, a native of Winchester, Virginia. She founded the Daniel Group, Attorneys at Law, in 1998. She's a graduate of UVA for her undergrad and from T.C. Williams School of Law in Richmond for her law degree. And she's also the vice chair of the general practice section of the State Bar. So with that, I'll turn it over to Mary.
Thank you. Hello, and yes, I'm starting my timer. I have to take at least 25 minutes because this counts as ethics, I'm told, but I know I'm the only thing standing between you guys and the next break. So I'll make it as interesting as possible, which is easier to do if you guys ask questions. Raise your hands and ask questions. I'm also going to leave my cards on the front table here. I'll set them down there when I'm done so that you can, if any questions come up after the fact or anything I can help you with, please feel free to email me. That's the best way. You can try calling. I might or might not be able to call you back, but you can email me. It's the best way to reach me. So you heard a little bit about me, but I want to know about you. How many of you are brand new lawyers? You got admitted in October or since October even? How many is it? Wow, okay, and that's kind of what I was expecting. How many of you have jobs? You have no idea how much better that response is this year than it was the last time I did this. Okay, this is, go, good for you. How many of you with jobs? There's an office manager at the firm or the operation where you work, an office manager, not a lawyer who also does the administrative stuff, an office manager. Okay, yeah, see, and then it starts to dwindle a little bit. And how many of you are from the big firms? And in my opinion, a big firm has more than 10 attorneys. That's not the standard, okay? How many big firm people? All right. Only a couple of you that did so much better in law school than I did. Okay. So, no, that's good. That just sort of gives me feels that most folks here are in a position where if there is a problem with charging your fees and billing, it's coming right back to you, all right? And even for those that are in the big firms and have office managers and that administrative stuff is something that somebody else takes care of, it's still your responsibility whether you like it or not. And eventually it's going to become part of your day-to-day reality and your day-to-day troubles. So this is one of the more important parts of being a lawyer that nobody bothered to teach you. And in fact, as a new attorney, I was fortunate that I did have a mentor early on who figured out, he was a managing attorney of the firm, who figured out that his job was easier if the very first timesheet I filled out was right, and if every single one after that was right. And most people don't get that because we're kind of late. Lawyers are kind of lazy as administrators and as managers of things. We're really lazy as a group, but it still doesn't change the fact that it's still our responsibility to know these things. I'll point out the section is called Charging and Getting Your Fees. These are two completely separate things. Two separate things, charging and getting your fees, okay? The first one I'm going to talk about is charging your fees. There are a lot of rules about charging your fees. Most of them, I do believe, are in the materials under 1.801, okay? There's a nice little list, 1 through 8. I assume that since you've been through 12 years of grade school, 4 years of college, 3 years of law school, and now passed the bar exam, that you can read that list of 8 yourself. And I love these things because it makes it look so obvious, right? It's real simple, and you know what, the amount involved and the results obtained. And that sounds great. That's way more complicated in practice than it is on these little lists. But the most important thing from this list is basically your fee has to be considered reasonable. And that's actually an ethics issue in Virginia, as well as a practical issue. And the problem is, like every place else that the law comes up with this reasonable standard, it can mean different things to different people. And it can be perfectly ridiculous. And again, the rules know that. Because what might be reasonable, frankly, I hope my billable hour at this point, I'm hoping, but I'm not sure, I hope it's higher than most people who just passed the bar. Because it would be unreasonable for me to expect my clients to pay somebody who has zero experience or 0 to 6 months of experience to do the same job that I would do. At the same time, it's unreasonable for them to think that I can do that job at that lower rate, right? And it's unreasonable to expect my new associate to be able to do the job I do in the same amount of time that I do. Because if after coming on 20 years now of doing this job, if I'm not a little more efficient now than I was 20 years ago, obviously I've missed something important and I need to think about a new career. So the reasonableness is, it sounds so easy to say, but we got to watch it, and it changes with the circumstances, it changes with the client, it changes with the case, it changes with all of those variables put in there. Are there any questions about those 1 through 8? Because surely you've been reading them as I've been prattling on up here, right? No, you haven't. All right, so if you have any questions about what that means, think about it. You know, just kind of go through, and it's going to be different in this case than it is in that other case. It's going to be different in your firm than it might be in another firm. It's going to be different for you than it is for your senior partner or the people who are coming along right behind you in 6 months to a year. Okay. Contingency fees are specifically, are especially, let me put it that way. Contingency fees seem to be especially problematic from the reasonableness standpoint. And I think that's part of the reason they asked me to do this section, because most of what I earn on a contingency fee. And I can do the exact same amount of work in 10 different cases, and I will get anything from 0 to $100,000 on a case, any given case. I do a lot of judgment executions. That's what I do. You know, I could get anything in between and be doing the exact same amount of work from one to the other. So really, where the rules are coming down, there's something called the Mullins case, that if you ever have to defend yourself on a contingency fee, you would run into that. But really it comes down to the reasonableness is based on, there's an element of uncertainty. It's a wagering, if you will, that I get to, I win some and I lose some, and my clients do too. That means I have to be particular about my clients. I have to be very careful about who I choose as my client, which gets us into number 2 on here. Always get a written fee agreement. A large number of attorneys don't do this. I'm going to tell you this. Who am I? I'm telling you this because of my experience. I'm also on the disciplinary committee, 7th District Disciplinary Committee. Hopefully I will never meet any of you through that. And I also have insurance. Some lawyers don't do that either. I also have insurance. All 3 of those things accumulate to tell me always get a written fee agreement. Okay? The elements of what should go into a written fee agreement are again in the materials, 1.806. For a contingency fee agreement, that always has to be in writing. You can never have an unwritten agreement for a contingency fee. But I highly recommend that you get a written fee agreement for any kind of fee. As I said, the elements are in there. If there's anything that you're not sure of or that you think maybe should be in a specific fee agreement that isn't, it's one thing to look at these materials, but this is where it's really important to have a mentor or somebody you can trust with experience in these things, which by the way might not always be a lawyer. I've had some office managers that I've dealt with, not even office managers at places I worked, that I've considered to be very good resources on how to what to include in a fee agreement, how to go about managing and maintaining that contract, make sure that we're doing what we're supposed to do to keep it enforceable. Number one on your list under 1.806 fee agreements is to describe what the lawyer is doing and not doing. What the lawyer is doing and what the lawyer is not doing. That is equally important in a fee agreement. I have almost never seen a case where a client complained or a judge reprimanded or a disciplinary committee reprimanded because the attorney did what was in the fee agreement. What you get in trouble for is when you're not doing something because, in the lawyer's opinion, it was not included in the fee agreement, and yet the fee agreement doesn't specify that. And you get a lot of these fee agreements that I see floating around that just sort of say, yeah, I represent you. And as nice as that might sound at first, and as expedient as it can be in practice, it puts you on the hook for everything all the time. And that's a really, really big deal. Because if you're representing in one area of the law, let's say domestic relations, you guys said they're separating from their spouse. All of a sudden, if you aren't specifically the domestic relations attorney, there is an implied responsibility for you to be sure to keep them apprised of anything that's really important in bankruptcy, in estate planning, in tax matters. Whatever might come up, can come up. And this is, I'm making it sound a lot more obvious as I stand here than it is in practice, but that's the problem, is it's not obvious when you're doing it, what you're failing to do, because it's, in your opinion, outside of your expertise, outside of your retainer, outside of your representation agreement, I mean. You need to know. You need to specify that. You'll see on the list the other things that are, and these come from the LEOs, the legal ethics opinions. You'll see the other things that are suggested, recommended to be included in a fee agreement. Again, on a contingency fee agreement, that always has to be in writing. Don't ever try to enforce a contingency fee agreement if Exhibit A isn't your written signed fee agreement. Though, in other things, you can get your fees under other circumstances. But the most important thing, here's the one thing, when you walk out of here, you've interviewed your client, you've discussed what your fees are going to be, everybody agrees they're going to be reasonable. They've got pen in hand, you're about to sign that fee agreement. This is the most important thing to remember. Trust your gut. Trust your gut. If you have a bad feeling about this client, don't represent them. And we have been trained now for years and years and years to put our heads above our hearts and to not trust our gut. But if you've got a bad feeling about this one, don't do it. Because it's just like any other relationship you've been in, when you've got that just a bad gut feeling, even if it just means you're not going to get along very well, you don't communicate well, or it could be that this person is outright lying to you, or they think you're a jerk and they're going to try, they're already scheming on what they're going to do. It doesn't matter why you've got that bad gut feeling. If you've got a bad gut feeling, do not undertake a representation. Just don't do it. Because the next client's out there. They're waiting for you. They're looking for you. The next one's out there. So, like I said, that's the most important thing for me to communicate to you today. The clients who say that your fee doesn't matter are the most dangerous ones. You need to, as soon as you hear that, even if you got a good gut feeling about it, you think, oh, this is going to be a great case, and this person's really fun, and they really seem to get what's going on. If they say that it's not the money, it's the principle of the thing, I strongly recommend you immediately double your retainer and you double your estimate for the amount of time that it's going to take. Sometimes that's fine. And if that's fine, then it really isn't the money. It's the principle of the things. And those can be the most rewarding cases. But a lot more people will say that on the front end than believe it on the back end when it's time to write the check. So that then brings us to the second part, which is about getting paid. Okay, again, I think everybody probably knows there are 3 kinds of fees. You get an hourly fee, a contingency fee, or a flat fee. You can also combine these. That's in the written materials how these things can go. But the number 1 rule for making sure that you actually get paid is to bill regularly. Bill regularly. This is your most important communication with your client, is your bill. They will skim over those letters. They'll be, playing on their cell phones while you got them on a phone call, whatever. Clients look at their bills. And if it's not on your bill, you didn't do it. As far as our clients are concerned, not as important. It's true for if the judge looks at your bill or if anybody in the state bar ends up looking at your bill, that's true too. But if it's not on your bill, you didn't do it. So make sure everything you do is on the bill, even if you don't charge for them, for what you did. And make sure those bills go out regularly. I've never had a client complain to me that they just heard from us too often. We just did we really need to let them know every little thing we ever did? I've never had that complaint in 20 years. I did have one who asked me to just send him updates once a week. So, but that's as close as I've ever gotten to that. So pay attention to your billing, get it done regularly, read it over before it goes out. This is where it starts getting tricky in the day-to-day management and administrative operations of wherever you work. Read that over because that is your most important communication with your client. Invite questions of your bills. We all make mistakes, and sometimes it's not a mistake. It's just an opportunity to educate your client on what you do, why you do it, how it gets done, things like that. Always keep copies of your bills. This has been a decreasing problem. It used to be a lot of lawyers, they sent out a bill and they didn't keep any copies of it, and they were all kind of hand typed by somebody whose job that was. Thank God for computers and automated billing systems that make even lazy lawyers that don't want to deal with that sort of distasteful administrative stuff. We put it into the computer and there's usually at least a PDF copy somewhere. But make sure that you know what you've billed your client for, so that if a question does come up, whether it's the day after the bill goes out or the statute of limitations minus a day from when the bill goes out, you'll be able to recall. It'll be thorough. It's your record of what you did, and you'll know what the questions are about. If your bill is unpaid, act promptly. Okay? We all have lots of opportunities to do pro bono work, and I strongly support pro bono work. I do a lot of it myself. Try to know when you're doing pro bono work before you're doing the pro bono work. Okay? This is the trick. You can work the mantra in my office. We can work and get paid. We can not work and not get paid. What we don't want to do is work and not get paid. Okay? So, and if anybody can figure out how to not work and get paid, just let me know, because I've never figured that part out yet. But doing your little diagram in your head, we're trying to avoid the one where you work and don't get paid. And the only way to watch out, because there are a lot of reasons your bills might not get paid promptly. One of them, by the way, is the bill didn't get where it was going. You've got a bad zip code, you've got whatever, bad email address, somebody moved, whatever. Better you bring that up now than 3 months from now when somebody didn't even realize they owed you this much money. But there can also be other circumstances that you need to know of. If you've got a financial hardship by your client, if they already think you're not worth the money and you're not done the representation, you need to know that. You've got to know that. This is still the most important communication you're going to have with your client. If there is an issue with the fee and the fee is disputed, there is the Fee Dispute Resolution Service at the Virginia State Bar. Up until 6 months ago, I talked about this in a purely abstract way that I was aware of it intellectually and had been there or had seen the forms and things. I can now tell you from personal experience, it is an excellent program that the State Bar runs. It again takes most things from it takes a dispute from the standpoint of communication, education, understanding. And it's a great system. It is, you know, I mean, there's a dispute, so it's technically adversarial, but that is not the way they deal with things. As it goes through, it's sort of done more as a mediation, if you will. And it's a really great program that is underutilized. I can also tell you, I feel pretty strongly since I've been on the disciplinary committee that it is underutilized by lawyers. And lawyers should be looking at the dispute resolution process, fee dispute resolution process, in order to sort of head off some of the other issues that I see in the disciplinary. Because really, a lot of them, at the end of the day, we go, and you know, if they just had felt like they didn't have to, you know, were overcharged for it, they might not have gone to the extent they went to on the disciplinary side with the clients. So anyway, I highly recommend it now, not just from philosophical belief, but from personal experience. The Fee Dispute Resolution Service is really great. Fiduciary compensation, anybody here doing fiduciary work? That's really fun if you get the chance. I liked it. You know, I've liked it when I've gotten to do it here and there. The fiduciary compensation information is at 1.803. That's kind of a unique blend of things. And as far as I can tell, I shouldn't say it so bluntly, but fiduciary compensation tends to be a really educated guess on what is fair and reasonable under the circumstances. And again, it can change dramatically. It used to be a 5% fee, for example, for a trustee on a foreclosure. Trustees charge 5%, period. That was it. It was done. And in the last 4 years, that has changed completely. It has changed entirely. So, finally, the most important thing about charging and getting paid, I'm going to check my time because I want to keep you, oh, look at that, I got 3 minutes and 15 seconds. Termination of your representation. The client has a right to fire you. Super. The client has the right to fire you. Don't forget, you have the right to fire your clients as well. Okay? We all have to agree. We're in the same boat as doctors and most other professionals. If we're just not getting along, and this is not a productive relationship, somebody has to say, I break with thee, I break with thee. And anyway, it can be done. It has to be done responsibly. You keep in mind that everything that's produced as a result of the representation belongs to the client. Always give the client back their file. Little section in here about paying this and paying that. Just give your client back their file. Always give them back their file. The only question is, what are you going to keep copies of when you hand them their file? And that's, you know, you can keep a copy of the whole thing if you want, or you can just keep copies of parts of it if you want. Do not hold a file hostage to get a bill paid. Do not ever do that. It is not worth it. I don't care how big the bill is. Because the minute you're holding a client's file, you are putting them at a disadvantage for finding a new attorney or just moving on themselves with whatever their legal issue is. So always give them back their file. And finally, disengagement letters, 1.808. Another one that my insurance company would like me to emphasize to everyone, a disengagement letter. It sets clearly what you have done, that you are no longer doing it, and by the way, if it's ever necessary, it also sets the date for the statute of limitations that starts running. But that way there's no question that you are no longer doing this job for this client. And I have clients that I have ongoing matters for. I have some of them hundreds of files for. We send a disengagement letter on every file when we close it, so they know, even though I got the other 99 out there, this one, as far as I'm done. And once in a while, they call me and go, no, 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 you're not done yet. Wait, there's still more to do. And then I send the letter that says, oh, yeah, okay, see, good thing. If I hadn't sent the disengagement letter, they would have thought I was all over this other set of facts out there that I didn't know about because nobody ever told me. So the disengagement letter is at 1.808, and if you ever need to see an example of one, just let me know, because I can print out a couple of extra any given day of the week for anything. Do we have any questions on anything? So everybody's bill's getting paid, because you guys, usually I do this like the day after the bar admission. Nobody's even sent out a bill or anything. Everybody knows what I'm talking about. But most of you have jobs, which is great, and have probably already started doing that point. Now all your clients are up to speed, right? It's all good, because it's sort of like, I don't know, scars and stuff like that. The bad debts sort of pile up as you get older and as time goes along. So the better care you take of yourself young, the better off you'll be. That's my, yes, sir?
Did you send a disengagement letter after you successfully resolved the case, or only if you've done work on it and nothing really came of it?
I send it, we cannot close a file in my computer system without sending a disengagement letter. I've got one, in fact, that just yesterday, an attorney who had to withdraw from representation of a client that I had a different matter. You know, I knew this client on other terms. He had an issue. He was not able to, say, appear in courts for a period of time. So I entered an appearance to be a placeholder. He's back in. I'm sending them the disengagement letter, even though my engagement letter clearly states that I was only in that case until they found new counsel or the proper counsel. And so that's all I did was a placeholder. I found one piece of paper 6 months ago, and they're getting their disengagement letter. Hopefully it's being drafted as I'm speaking to you, but certainly on Monday, I'm sending that out that says, essentially, nothing happened, which is exactly what we planned. And they're moving on to the next, the substitution of counsel's going in as well.
Well, Mary Louise, thank you so much for speaking. And speaking of disengagement, I think it's time for us to disengage for a few minutes, grabbing coffee. We'll come on back here in, let's say, 2:30 and hear from Judge Spencer at that time. Mary Louise, thank you again.